Hello, this is Jay Milligan, the managing partner here at Milligan and Higgins Law Firm. So we're going to talk about some frequently asked questions that we get, particularly as it relates to OUI investigations. And one of those is kind of a twofold question. One is, do you have the right to an attorney prior to conducting field sobriety tests with a police officer or state trooper? Second part of that question is, do you have the right to refuse to take field sobriety tests when asked by a state trooper or law enforcement officer? So let's just start with the first part of that question. Do you have the right to an attorney prior to field sobriety tests? The short answer to that is no. And here's why. Field sobriety tests are generally considered what we call pre-arrest screening exercises to determine if they have enough evidence to prove or show under probable cause standard that you're impaired by the ingestion of alcohol. So you do not have the right to a lawyer at that point because you haven't technically been arrested. So Miranda warnings don't apply at that juncture. Miranda warnings are only applicable if two things occur. One, you're placed under arrest or you're in custody. And two, they're going to ask you questions. So just because they place you under arrest, they don't even need to give you Miranda warnings at that point if they're not going to ask you any questions. But generally speaking, at a police station, part of the protocol is they will always advise you of your Miranda warnings, make you sign a form, and then move on to other rights that you have at the police station that we'll talk about in further videos. So the second aspect of the next question is, do you have the right to refuse field sobriety tests? And the short answer to that one is yes. Here's the kicker. The police do not need to inform you that you have the right to refuse, but you always have the right to refuse to give them evidence, particularly as it relates to field sobriety tests that'll include like a 9-step walk and turn, a one-leg stand, that really are balance and coordination tests. And you may not be balanced and coordinated. You may have medical issues. The only thing I would say, or my piece of advice is, just be polite. So if you're going to refuse to take field sobriety tests, you want to say something along the lines of, I appreciate the offer or something along those lines, but I'm going to respectfully decline to take those. Or because of some medical issue, you don't feel comfortable taking those exercises, something along those lines. But just be polite. Now, granted, once you refuse to do field sobriety tests, the officer or trooper is going to place you under arrest. They're not going to let you get back in your car and then drive away. But by refusing to take field sobriety tests, you've limited the government's ability to get evidence against you. And more importantly, your refusal to take field sobriety tests is never admissible against you. So in short, your case would be the trooper or officer testifying about whatever driving behavior they observed, maybe some observations inside the car, maybe an observation about how you get out of the car as being unsteady or unbalanced, or whatever they want to say. But the investigation at that point would conclude, meaning the trooper or officer would not be able to testify, well, I asked Mr. Smith to perform the field sobriety test and he declined. That evidence is never admissible at a trial. So that's very important to realize. So hopefully that answers your questions about whether or not you have the right to an attorney prior to field sobriety tests and your right to refuse.